All rise. The Supreme Court of Guam is now in session. The Honorable Chief Justice Robert J. Torres presiding.
Today, you may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA23-012, People of Guam Plaintiff Appellee v. Paris Christian Regis Sharpe, Defendant Appellant. Appearing for Defendant Appellant is Attorney William C. Bischoff. Appearing for Plaintiff Appellee is Attorney Christine S. Tenorio. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Attorney Bischoff reserves 10 minutes.
You may proceed, Mr. Bischoff.
Thank you, Mr. Chief Justice, and may it please the court. So why not allow more discovery, more evidence available to both parties, particularly to the defense? If we know more before trial, the case might get dismissed, or on the other hand, if the more information that we know before trial is adverse, it proves it or attempts to prove defendant's guilt, we may have a plea bargain. Nobody wants to listen to the whole sordid sex life of a couple, and the attorney-client privilege, especially in a case where there's no corroborating evidence like this, it makes sense that the
Mr. Bishop, can you walk me through your objection, first of all, in terms of the hearsay objection? What statements are you objecting to in terms of the trial court admitting evidence that you felt violated the Guam Rules of Evidence 801B? So if you can just walk me through your argument in terms of the statements. As I recall your brief, you said the police officer's statements, and then under what provision of Rule 801B do you feel that the trial court err in reference to admitting these statements?
In my cross-examination of the PR, the alleged victim, we didn't intimate or expressly or impliedly assert that she was recently coming up with a story that I was surprised with at the trial. She was just telling one of the stories that she had told before. We asserted that neither of the stories was true, was correct, was factually accurate. So we weren't asserting that she surprised me at trial with a recent fabrication or a recent change of story. So there was no justification for the prosecution to get up there on rebuttal and just have her read her statement again, just go over it, say the same thing again that she had said on the direct examination.
So under what provision of Rule 801 did the trial court admit the objectionable statements in reference to, so what out of court statements? So you allege that when she took the stand, she was making statements that you felt were fabrications, or you allege were fabrications. And so what prior consistent statements did the government seek to introduce, and how is it that you felt that, or what is the basis for your argument that the trial court erred in admitting these statements? And if you could just be a little more specific.
She basically just reiterated her testimony on the direct examination about what she had said to Officer Lizama at the Dedido precinct on April 11th.
So does Rule 801 D1B, because you said that it was for recent fabrication, doesn't the rule allow under those conditions, if it's the out of court statements, the prior consistent statements, which in this case is the police reports, a reading of the police reports, certain parts of it that she recently fabricated, and isn't that a proper purpose for allowing the statement to come in?
It would be, but I wasn't claiming that she had that she had recently fabricated, that she had said anything new at trial that we didn't already know beforehand, that we hadn't even already brought up throughout the course of the trial, that she made wildly inconsistent statements at Healing Hearts and at the Delhi Police Precinct. So I wasn't at all alleging at the trial that there was a recent fabrication, that I was surprised that the prosecutions, that to open the door for them to go back and say, well, she said this statement way before this alleged motive to fabricate arose. Because I wasn't even saying that she had recently come up with some motive, a recent motive to fabricate a story. Our whole case was that she was delusional, she was angry, and as proof of the fact that she was delusional and angry, she was making wildly inconsistent statements, giving wildly varying dates about.
So did the trial court make reference to using the statement to bolster the credibility of the witness?
Right, that's the problem with that. Yeah,
And why is that a problem?
Because it just hammers it in again more and more. The complaining witness gets to go back up there on redirect and just reiterate her testimony again when it hasn't even been challenged as a recent fabrication.
Well, the people argue that because it's cumulative of what she testified to in direct, it's harmless.
Well, but then at some point it's not harmless. I mean, if the whole
What is
point,
that point?
I think, well, in this case, the fact that she was allowed to go up there and make and reiterate that statement about the testimony about what she had said to the police officer at the Delhi precinct, as if the defense was that was not true, that what she said at Healing Hearts was what was actually true. And of course, we weren't saying that what she told Healing Hearts was actually true. I mean, in both instances, at Healing Hearts and at the Delhi precinct, she alleged a rape. But they were very different stories about a rape, and we were saying that this goes to prove that she's just angry and delusional, and she's mixing maybe different incidents in her life, or maybe different incidents so that she had even with Mr. Sharpe and engrossing them and embossing them with other.
What was the trial court's focus when it was evaluating the admission of the prior consistent statement? I mean, did it analyze it under D1B, the recent fabrication, or was it focused on rehabilitation of her testimony?
I don't think the court actually articulated it either way, but even rehabilitation of her testimony, if it's just to go up there and say the same thing over again and just by repetition to make it sound more convincing to the jury, make it more convincing, then either way it's objectionable.
Well, I mean, I bring that up because it doesn't appear in our rules of evidence that the 2014 amendment that was adopted to 801 has been incorporated into our rules.
The 2014 amendment to what, the federal?
801 D1B, our current rule, the Guam Rules of Evidence, has 801 D1B. The federal rules of evidence has two separate subsections to D1B. There's D1BI and D1BII. And our rule only has rule D1B as a standalone, that when the statement is not hearsay or is excluded, when it's consistent with the declarant's testimony and is offered to rebut an express or implied charge against the defendant of recent fabrication, or a declarant of recent fabrication or improper influence or motive. our current Guam rules of evidence do not have the comparable provision in the federal rule for rehabilitative testimony. And that's why I was asking about what the judge's focus was at the hearing. I mean, I saw one reference in the record where the judge appears to cite the federal rule after it's been amended.
I'm not sure, was that federal, was that intended as a change or as just a clarification of the prior rule? I don't see much of a substantive difference there.
Well, that's what I'm asking you.
Yeah, okay, so.
Yeah.
all right.
I mean, if you feel that the addition doesn't change the impact of the rule, well, that's your position.
Right, I mean, I'm sorry, I'm not as familiar as I should be with the change in the federal rule, but from what you recited, it doesn't sound to me like it made a substantive change to the.
Well, the change that was made to the rule by the 2014 amendments was that the prior consistent statement's not hearsay when it's offered to rehabilitate the declarant's credibility as a witness when it's attacked on another ground. And so, I mean, obviously, it's not just a regurgitation of what was contained in the rules. They felt they had to make an amendment for some reason.
But it still has to be to rebut an allegation of recent fabrication, right?
Oh, that's what I'm asking you, if you feel that that's the case. It seemed like the amendment was enacted to challenge or to when the declarant's credibility as a witness is attacked on a ground that's different than what's contained in what is our B and under the federal rules is now BI.
I doubt that was meant to overrule the tome case.
Yeah, well, Tom only addressed the one factor, only addressed the fabrication issue.
The recent fabrication.
Yeah, Tom never really addressed the rule because the Tom decision, I think, predated the 2014 amendment,
Right.
if I'm not mistaken.
Right, so I don't.
So Tom would clearly not have addressed the 2014 amendment.
But I don't think
the
the
federal
2014 amendment was intended to overrule Tom.
No, it wasn't.
Okay, so.
So I'm a little confused. So your argument is that there was error on the part of the trial court in admitting the police certain parts of the police report read into the record and the statements to Healing Hearts, because there was no recent fabrication when she took the stand, because those were consistent statements. Those statements were what she was alleged from the onset. I'm trying because when I'm following your objection, you're saying that it has to do with recent fabrication, and our Guam rules 801 allow for prior consistent statements if the conditions are met that are used to establish consistent with the declarant's testimony to rebut against the declarant of recent fabrication, improper influence or motive. So our 801 does have that. Now, CJ Torres is pointing to a counterpart in the federal rules that goes beyond that and that provides for challenging a witness's credibility, which our rules don't have in reference to the using prior consistent statements to rehabilitate the witness's credibility. And so if your objection is only limited to the fabrication part, that's provided for in our rules. And so if that's what the trial court did, and I'm asking, what did the trial court do if that they didn't? If you could just clarify that for me.
So the trial court permitted the prosecutor to just have her recite her same story, the whole thing over again. I mean, like in the Kamadou case from this court, you recite from Wharton's.
So you're saying that because these statements were just repetitious, they're hearsay of court statements offered approved, they're not having nothing to do with recent fabrication or credibility.
Right, and the prior consistent statement is supposed to be admissible. A prior consistent statement must also respond to the specific point on which the witness had been impeached. That's from your Kamadou ruling.
Was
And
the prior consistent statement offered here, was it in before, the alleged fabrication or after the alleged?
I never alleged a recent fabrication. I just, both of those statements were made on the same day at Healing Hearts and at Deadydale Precinct.
Well, I mean, but the rule looks at the motive to fabricate. And, you know, so the idea is that if there's a motive to fabricate the information, that a prior consistent statement that was made before your motive arose to fabricate would be admissible. That's, I mean, it typical would be like in a plea agreement. You entered into a plea agreement, but you made a statement before you entered into the plea agreement. It would essentially be admissible because it would predate the motive. And so in this case, are you asserting that the motive to fabricate the story arose before she made that statement to the
Yes,
police?
that she was angry and that she was delusional. So the motive to fabricate arose because she made those two stories on April 11th. Just when she told those two stories, and she had a motive she was very angry and she had the motive to fabricate combined with her delusional problems. Way back then, we didn't say that I didn't say there was any recent motive to fabricate.
So what is the point in time? What is the event that we are to measure pre-motive or post-motive? What triggers the spatial time period in which?
I think what triggers it is if the defense asserts that she's up there now telling a different story because now
So
she
when
has
she
a
took
different
the
motive.
stand and she started testifying in reference to her testimony at trial, you're saying that's the interval or that's the event in which we are to then determine whether it's a prior consistent statement.
Yes, I think it's triggered by the cross-examination asserting that she has a recent motive, that this is a recent fabrication, that she has not somehow changed her story. And that's what gives the prosecutor the justification to go back and say, no, she said this way before this time when the defense counsel says that she came up with this, that she found this motive to fabricate. That she said this even before she had a motive to fabricate. That's the rationale for the rule, as I understand it.
So we don't have an issue then that the out-of-court statements were prior to the time to fabricate, because it was these police report statements to Healing Arts, those were all made prior to her taking the stand. Those are then the prior consistent statements. I mean, the example is that when you enter into a plea agreement and you're now taking the stand testifying and you make statements and there is a challenge, and if the prosecution says there were statements made prior to the entry of the plea agreement that was consistent with what he or she is making on the stand, then there is the motive to, I'm just trying to understand what is the triggering event for us to measure these time periods.
So let's say that all of her statements were made after she already had the motive to fabricate. I mean, this motive to fabricate had been growing in her for days. So she had the motive to fabricate when she made both of the statements on April 11th at Healing Hearts and at the Teddydale precinct. And at trial, I didn't assert that she had all of a sudden changed some story and that now she has a new motive and that she's changing her story because of some new motive or some new
So
recent that it's a recent fabrication.
Yeah, so your argument is that the motive, the statements that she made to the police came after she had the motivation to fabricate.
Right, and I think the triggering point that allows a 801 this prior consistent statement is if the defense counsel implies or expressly or impliedly states that she is telling a different story now at the trial, that she's come up with this some recent that her trial testimony is a recent fabrication.
And you didn't say that.
I never said that. No, that was not our case at all. In fact, our case was that she told these several different wildly inconsistent stories.
Can we go to the intersection of the Sixth Amendment and the attorney-client privilege? You're asking the court to look at a standard that proposes we review the statements and as if it doesn't incriminate the client, then you allow the privilege to be pierced. And but yet no other jurisdiction has adopted that test, right?
I'm not sure, but there's no reason why you couldn't. I mean,
well, I mean, there are different approaches to doing it. One, basically says, no, the attorney-client privilege yields. The other is the Sixth Amendment yields. And then, a third test is looking sort of at a balancing of the factors on a case-by-case basis.
right. That's then from that law review article that I have sort of based my argument.
But the standard that has been suggested there is a little different than simply a balancing test. It basically says that the court look at the privileged communication, and if it incriminates the client, then you don't allow the privilege to be pierced. But if it incriminates him, then I'm sorry, if it incriminates him, you don't allow it to be pierced. But if it doesn't, then it can go forward.
Right, and especially in these sexual assault cases where you have a alleged victim that goes and gets a protective order at first, and then maybe changes her story. It's like anything she says to the prosecutor gets turned over to me in discovery. And it's important whether we don't want sexual assault complainants to go to a civil law center and try to get some sort of advice about how best to state my claim. And not that they're doing that at GLC, but if there are indications that a complainant goes there and is seeking advice about how best to state a sexual assault claim, then that should be made known to the defense. There's no reason why not. It's almost like it's akin to the crime fraud exception.
So you think the first step would be the court to have an in-camera review of what was said?
Yes. I think this court ordered something like that in the Rugante Medeiros cases a few years ago, where there was a forensic report of the alleged victim that was not turned over, and the court, I think this court remanded for the trial court to review that in camera, and I think it was in camera, to decide whether it could make a difference, could have made a difference that had been turned over prior to the trial. I don't know what she said at the, she says so many different things. I suspect she said something, even a third, story, but I don't know. And it could have made a big difference if maybe she didn't say anything, and that'll be that. The trial court will say, no, there was nothing there, and your motion for a new trial is denied.
So that's what you're asking for, a remand for a new trial?
Yes. Yeah, and especially in a case like this where there's no corroboration and where the complainant has gone to a civil attorney, and we don't, and if it looks like she was looking for advice about how to best state a sexual assault claim, that's important.
You're asserting that both the confrontation clause and the compulsory process clause protects your client's right, one, the confrontation to cross-examination, and the compulsory process clause to be able to put on the evidence. Do we look, is the test the same for both? Do we, I mean, in terms of how we address it, do we look at them separately? Do we look at them combined? Do we look at them on are the standards the same? Or what standards should apply?
Well, I guess you cross the compulsory process bridge first, and then see whether there's anything that should be used. It should be able to be used to confront the witness with on the stand. I think the ruling would have to be that in a case such as this, particularly in a sexual assault case, where you have no corroboration and you have adults that you would think would have, an adult complainant you would think would have got her story straight right from the beginning if this had actually happened. You would then there's reason to have the trial court in camera interview the civil attorney and find out what the complainant did or did not say that may be of relevance to the guilt or innocence of the defendant. It's a criminal case. He's doing 10 years in jail.
You reserve 5 minutes. You have 3 minutes left, Mr.
All right, thank you.
All right. Ms. Tenorio.
Mr. Chief Justice, may it please the court. This is a case where a woman was sexually assaulted, went to the precinct for help. They did not initially help her, so she went to Guam Legal Services to obtain a protective order so that she could be safe from harm. It was the Guam Legal Services advocates who directed her to Healing Hearts for further services, and then Healing Hearts.
Do you know that, Mr.
It was in the record, in the transcript. The complainant, RP in this case, she testified that it was Ms. Kinari who told her to go down there. And then also the Healing Hearts employee said that the victim was referred by Guam Legal Services employees. So Healing Hearts was the one who actually referred RP to the police to make the actual complaint, which didn't come until a week later.
Victim
Correct.
waive her attorney-client privilege when she testified?
The victim,
About what she said to, and they said to her at Guam Legal Services?
the victim did not waive her privilege. Under the attorney-client privilege, you may ask a victim still what she had told her attorney. And also, these facts were already in the filed declaration on April 5, the declaration that was accompanying the permanent protective order. So the statements that she had given were already contained in that order. The attorney-client privilege doesn't prohibit the victim from being cross-examined about the communications. She is the holder of the privilege. You just cannot cross-examine the attorney or the advocate about those communications.
But isn't the privilege, afforded to the client? And so when the trial court allowed her to be both the prosecution and the defendant to inquire about her communications with Guam Legal Services, and she went forward, why didn't that waive the privilege and allow him to then cross-examine her while she was testifying?
So that did not waive the privilege because she was merely testifying to the things were already in the declaration. So the rule that Mr. Bischoff would like this court to adopt is that anytime that a victim goes to get a protective order, she automatically waives her privilege by filing a declaration with the contents of the communications between her and her attorney. That is not the case. So even if she testified, she's merely testifying to what is a public document into the.
Yeah, but what about the testimony that was elicited about her oral interview being more detailed than the signed declaration? I mean, how, that's not information that's contained in the declaration. She testified as to that.
What I recall her testimony being is that, yes, it was longer, but not that it was more detailed. She actually said, I did not tell Healing Hearts, Miss Canary. I did not tell her any of the details. I merely stated I was sexually assaulted. And that is the particular phrase that is found in the declaration accompanying the protective order. Also, for the victim advocate and the attorney, that communication would have been protected because under the local statute where we've adopted the privilege, there's a provision that's a safeguard actually to the defense. It says the privilege is no longer employed if the advocate and the attorney know that there's exculpatory information contained in the privilege, or if the victim's going to perjure herself. So having that information, the Guam Legal Services attorneys and the advocates, they would have known that they would have had to disclose something if it was exculpatory or the victim was going to perjure herself. They did not. So to us, and again, I don't have access to that file. I don't have possession of those records because this is a law firm. And the law firm was the one who moved to quash the subpoena that Mr. Bischoff had issued. They actually moved to quash my subpoena as well because I had subpoenaed the advocate for trial. So there is a safeguard in place. And so presumably if they go on the motion to quash and say this is protected, then that means there's no exculpatory information in their file. So I do not think that she waived her privilege by merely testifying. I don't think that the rule stands for any time someone is getting a protective order, they automatically waive the privilege.
If we were to assume that by taking the stand, testifying as she did, that she did waive the privilege, then could Robert Cruz, still continue to refuse to be compelled to testify on the stand?
I think that would be up to them as an attorney
But
far as
the attorney is not the holder of the privilege.
right. So Mr. Cruz, I think, only could have testified if the court ordered him to, given the waiver. But the procedural posture below was that the attorneys.
We're dealing with constitutional rights here, counsel, and right to confrontation and to compel the witness to appear. And so if we assume that by taking the stand and she testified to the statements that were transcribed into that we are able to read, and so could the lawyer continue to refuse, and was the trial court correct in quashing the subpoena in reference to addressing the Sixth Amendment rights of the defendant in this case to confront the witnesses that he or she is requesting to appear in court.
Her lawyer could have still continued to refuse to testify, given that he did not think that she waived it, because there was a hearing before trial started.
But if we
wherein-
were to assume that there was a waiver by her taking the stand,
If we were to assume
what
that
are the concept? What are the results that follows under the attorney-client privilege?
if we were to assume that she waived, then because the privilege would have been assumed to be extinguished, then her attorney or the advocate could have been compelled to testify. But the way that the trial court analyzed it was a limited waiver only. And she actually only waived the privilege as to the initial day she arrived. And arguably, that wasn't even covered by attorney-client privilege because they did not have that relationship yet. The day she entered the door, that's of Guam Legal Services, that's the only fact that we were able to elicit through the testimony.
So she can pick and choose to the extent of what she can waive. I'm not sure if that's how the attorney-client privilege works.
Right. So I think that's my argument, is that she actually didn't really waive the privilege at all. Because even though it was construed as a limited waiver because she was waiving as to the day that she came in and arrived, she did not waive any communications that were protected. So I don't think she actually waived it at all. We were calling a limited waiver because there was a dispute as to whether demeanor falls under attorney-client privilege. And I think the case law that I've cited indicates that demeanor is not protected by attorney-client privilege. And they weren't even attorney-client, they weren't in an attorney-client relationship anyway. So I don't think that by testifying, though, that she waives the privilege, because then in any case, basically, if you are a victim in a criminal sexual conduct case, that means anytime you've had a lawyer, a defense counsel can subpoena that, and it automatically extinguishes the protection.
It's an in-camera interview to determine, in this case, it seems Mr. Bishop argued she was perjuring herself.
To that point, I do want to address that. What they had requested below was in-camera testimony. They did not ever issue a subpoena ducis tecum for the file. It was before the trial, they issued a subpoena for Attorney Cruz and Ms. Canary to appear at court. After the trial, for the motion for new trial, the request was the trial court had to take in-camera testimony. But my argument is, how is a judge supposed to know what is exculpatory or what is not? Because here, the trial court's holding was this. It was that because he already had the information from the conversation between the victim and her lawyer, as filed in the declaration, that the confrontation clause was not violated because he could still bring out whatever inconsistencies he could deem from there. And there was an inconsistency. That I want to highlight that because the defense's attack is, we don't know, one, what she told them about the date that she was sexually assaulted, and two, what she told them about details. The inconsistency with the date was already in the declaration. He was able to cross-examine her extensively about the wrong date, alleged wrong date that she told Healing Hearts, and that wasn't even the date that the prosecution had alleged that the victim that the sexual assault occurred. So any inconsistencies that he wanted to glean were already on the record. I want to talk about the point because it's related as far as what were prior, and that's the thing is, this in-camera review by a trial court would actually require prosecution to submit all versions of all statements that a victim has ever told anybody. And then the trial court would have to conduct an in-camera review, parsing out for themselves what they think is inconsistent and what they think is not inconsistent. So for this case, even if they had submitted to an in-camera review, we would have had to turn over discovery to the trial court. We would have had to turn over the healing heart statements, every police interview, and every Office of the Attorney General interview. And as I've cited in my case, there's at least, or in my brief, there are at least 2 jurisdictions that do not allow that, specifically under the victim advocate privilege, because they're saying that the full and frank communication between a victim and her advocate, or his or her advocate and the lawyer, are to be protected under their statute for the victim advocate privilege mirrors Guam statute. So for them, they indicate if you can get this information elsewhere without breaching the privilege, then your confrontation clause rights are not violated. And he did get it elsewhere. It was within the filed declaration. The other related point as to prior consistent statements, I want to go through the order of the testimony because it will help understand why the trial court allowed the prior consistent statement is and what exactly the prior consistent statement was.
Before you do that, what was the basis of the trial court's admission of the prior consistent statement?
So I had argued that under People v. Asper and People v. Comedy that this court had indicated when a motive to fabricate arises on the stand, that this court has held that we can bring in prior consistent statements as to the point that they are being cross-examined about or that they're alleged to have lied. In response, the trial court agreed with that the case law said that, and then also trial court made an additional comment. This is also going to her credibility to rehabilitate the credibility.
But did the trial court rely on the federal rule of evidence that doesn't exist? I mean, it cites it in.
Although the trial court made the comment, the trial court did not specifically cite to the rehabilitation provision that Your Honor brings up.
On page 36 of the transcript on that date, on the June 15th, 2023, the court specifically says we're talking about 801D1B II. So
for that, I think it was twofold. So if I'm corrected as to him relying on BII and he's using, or the trial court was using the amended rules, there was also a finding that it did come in as a prior consistent statement under the current rules, 801DB1.
Just D1B, yeah.
Right. So it was twofold. But the reason why I bring this up is this. The order of the witnesses matters as far as prior consistent statements. In this trial, the victim testified last. Healing Hearts testified first, and I want to clarify, defense did not dispute the admission because that came in under the statement for medical diagnosis. So that was not objected to. And it was actually the Healing Hearts version of events that defense used to argue that she was lying. So they had that wasn't prior consistent statement. They were saying that was actually the truth.
Well, I mean, he was suggesting that the motive to fabricate came even from the get-go. And in fact, if the fact that when she went to see the police on April 2nd, she didn't make a statement to the police at that time, or no report was made of a CSC then. And so, then later she says she reported it that evening. Police have no record of it. And so he's basically asserting that the motive to fabricate predated even her statement that she made to the police on April 11th, which was the statement that was read into the record.
During the trial, if you read the whole transcript and if you read the closing arguments, their arguments were that she lied on the stand and that she changed her version of events on the stand, and that she had also lied before. So it's the government's position that the motive to fabricate arose on the stand, and I had delineated all the different ways he cross-examined her. She was on the stand for a day and a half, and he was crossing her over everything that that they thought she lied about the stand while on the stand. The issue about the police not taking the police report, the police admit that they testified. They admit they didn't take a police report from her, which is why the first version of events comes from Guam Legal Services in the filed declaration. And as far as the the inconsistencies. So the whole trial premised on this. She was lying because she told Healing Hearts a different body position than she told everybody else.
Well, different dates too, right? That was
Correct.
part of me. There was the allegation, did the assault occur on April 2nd or did it happen in
On
March?
March 20, correct.
Yeah.
But the chief point made to the jurors was that if she got the body position wrong, then she must have been lying. But the reason why the prior consistent statement, and I want to clarify what it was. The prior consistent statement was the single statement by the RP, the victim. I had her read her written statement. So it wasn't her statement in the police report. That was a whole different statement. She handwrote a written statement to the police, which is on a separate sheet of paper. And she only read the portion that was in dispute. I made sure that she only read the prior consistent statement, which was the body position that she was in during the sexual assault. Because Mr. Bischoff tried to say that that she lied about it and the sexual assault positions differed. But the point of that was to clarify and correct the record that she had always indicated that her back was not against the wall. It was she was raped against the wall with her front facing the wall. And as far as Officer Lazama's rendition of that statement did not come from me. That statement was on cross-examination. The defense counsel said, and something about what was the body position, or isn't it true that the body position was this? And the officer clarified, and this was before RP testified, officer clarified, no, it was always clear she was raped from behind. So that's how the prior consistent came in, because it was to refute any statements made that she was lying on the stand to prove that
That's not the test, whether she was lying on the stand. Isn't it the test that she has a recent
fabrication? Correct. So that's what I'm saying. So that the test is recent fabrication. You're correct. But here, based on the cumulative cross-examination, the defense kept saying she was lying on this, or she had a recent motive. The recent motive to fabricate was basically she's tailoring her trial testimony to fit the circumstances so that we could get a guilty verdict. He cross-examined her on all different points that she lied on the stand, because he kept saying, isn't it true? You told them something else.
But if the allegation is she's lying on the stand, does that give the prosecution the right to bring in hearsay evidence?
It gives the prosecution the right to correct the record, because a defense counsel cannot say, well, you never told the police it in this manner when she actually did. So in that case, it would come in as prior consistent statement, but alternatively, it just comes in to correct the record for rehabilitation, even if it's not coming in for the truth of the matter asserted. Because prior consistent statements do come in for the truth of the matter asserted, but if it's not a prior consistent statement, it's just merely to prove that she had said something consistent before, and the jurors do with what that information, whatever they would like.
But if that testimony was the testimony that she provided on direct examination, why isn't that just bolstering her testimony? And it's, goes against the grain of why you're wanting to allow a prior consistent statement to be admissible.
So,
I mean, otherwise every prior consistent statement is going to be admissible.
it wouldn't, for this particular one statement that she read off her written statement, it was not bolstering, it was clarifying, because on direct examination, we're not allowed to ask them about hearsay or about written statements. On direct, a victim's never allowed to read the written statement. She's allowed to say what she told the police orally, and that's what she did on direct. Then she was crossed about what she told other people and whether basically her version was a lie. So then on redirect, that does permit the prosecution to bring in a statement that was consistent, made contemporaneously that same day, that she was correct in what she had testified orally. And
Was
she had
there a
produced it.
limiting instruction from the court on how that statement was to be used?
Not that particular statement. There, from what I recall, there was a jury instruction that says how to treat prior statements of a witness. And that jury instruction covers both prior inconsistent statements and prior statements. But
And what was that instruction? Did it say it could not be used substantively? What was it?
I think it says it's up to you it's a generic instruction that says it's up to you to decide whether someone has made those statements before and what weight you want to give it, if any.
But is that the law? On the use of prior consistent statements? And once it's been deemed, even if it was deemed admissible, that it's not supposed to be admissible for substantive purposes?
The law on prior consistent statement is that it can be used as substantive and it does come in as evidence if the trial court has made a ruling that it's a prior consistent statement. So I think that's why there was no jury instruction as far as to use it for impeachment only or as substantive, because the trial court had already deemed that it comes in as substantive. And this is especially, I do want to highlight, this rehabilitation came after the trial counsel had actually asked her to read her written statement first, but it was only as to the points that he thought was inconsistent. So the rule, if a defense attorney uses the same exact statement to prove that she is, incorrect or inaccurate, then the whole point of redirect is to rehabilitate the witness on the points that she was accurate on in the very same statement. So he had actually employed the statement first. And so that's why it came in.
But I think,
later.
There seems also the trial court may have been blurring this idea of rehabilitating the witness, which would have been permissible under the federal rule, and the prior motive to fabricate, which our rule has. We don't have the companion rule to the federal rule that allows the rehabilitation issue.
I think even in the absence of the modified rule, a trial court still has discretion, because we're judging this under abuse of discretion standard. A trial court still has discretion to admit a statement that is consistent after being attacked repeatedly, in this case for a day and a half, on every inconsistent statement she had ever made. And in this case, at the end of the day.
But if we didn't adopt that rule, why would that then be an exclusion to hearsay?
So this happens in other cases. So for example, if on cross-examination, a police officer says something inaccurate, a prosecutor can actually correct the record and indicate, but that's not what you had written in your police report. So all of the officers as officers of the court, we have a duty to make sure that the record is clarified and that what is in evidence actually comes out on the stand. Because if we let the record go knowing that that's an inaccurate statement, then that's, I think, a breach of a duty of candor, because it should be known that, the statements of inaccuracy should be admitted.
But can you just categorize what you're articulating? Because at least in my mind, I'm trying to sort it out. I mean, we have two categories of prior consistent statements, as I understand it, as CJ has pointed out. The statement that rebuts a charge of recent fabrication or improper motive, which is what our 801 B, whatever that the specific reference to prior consistent statements. And then there's the one to rehabilitate the witness's credibility. So it appears to me that there's a skewing of these lines, or maybe both, but I'm just trying to structure it in my mind. What is it that you're arguing that the trial court did and the prosecution advance? Was it for the purpose of rebutting a charge of recent fabrication, and that is allowed under Rule 80, the Guam Rules of Evidence? Or is it to rehabilitate the witness's credibility, which in specific reference to the rules, maybe case law is a little different, but the Guam rule does not adopt that subsection II of the federal rules. And so if we did not, and that was the basis of the admission to rehabilitate the witness's credibility, then do we have an issue here?
My answer is that we utilized the former, and it was in the trial court level, I specifically cited the former rule, or the out of the former and the latter that you had just mentioned, I cited the former. And when trial court ruled, he ruled that it comes in under the former, and then also in addition for rehabilitation. So
if the trial court is asserting that it came in because it was to rebut a charge of recent fabrication, the fabrication that's being alleged was fabrication that occurred before the statement was made on April the 11th. They're saying that she fabricated even when she went to the police on April 2nd, she didn't provide anything. And so if you look at the test in the Tome decision, it would seem that the time aspect is not satisfied for admissibility of this statement.
I would still say again, under looking at the actual cross-examination, that there was an implied motive to fabricate, and they were saying that she fabricated on the stand and that her prior healing heart statement was the correct statement. That's how we analyzed it below. But if this court were to find that it did not meet the temporal requirement, then my argument is still trial court did not abuse its discretion, and it was harmless error because, again, she had testified orally on direct examination to that exact fact. It was just in order to correct the context of the argument that she had never reduced it to a written statement, or to even confirm that she did say that. Because what happens is when someone says what they said orally, defense counsel's like, well, where's the proof of that? The written statement was the proof that she had said exactly in that manner. So if the court does not find the temporal requirement, we believe that it is harmless error. And that is in light of.
And the reason you argue it's harmless error is because it's cumulative, the prior.
It was cumulative because on direct examination, she was consistent and she had testified, he pushed me back into the wall.
But isn't a prior consistent statement always going to be cumulative? I mean, so isn't.
Correct. So, right. Yes, I understand what you're saying. However, I think it would be a different example if, for example, I was bringing prior inconsistent statement through a police officer. In this case, I think it matters that she was the declarant and she's just reiterating to the jury that she had already said this on direct examination and she actually had told the police this before.
But then that seems to bring up the dangers or the pitfalls of, because she said it so many times, it makes it true, as opposed to limiting it to the in-court testimony. And you're bringing in, this other prior consistent statement made out of court without, and it seems like you're trying to just bolster the credibility or continue to repeat the statements.
In this specific case, if it was to be analyzed as bolstering the credibility, then I could have just brought in an officer to repeat exactly what she said that was consistent, or brought in the investigator to say exactly that what she said was consistent. We limited it to just the written statement because the jurors had already found use of the written statement and they're wondering where is the rest of the written statement. And that was a proper procedure for us to bring in. And it was only a few lines. There was only 2 lines of what was actually brought in as a prior consistent statement.
And what was the purpose of that? Was it to prove what was in the statement, or was it used for purposes of rebutting that it was a recent fabrication?
It was used to rebut that there was a recent fabrication because it was used to prove that she was always consistent in the way she had said she was raped.
And so I guess that then the question is, Justice Merriman, was there limited instructions for that purpose so that the jury would understand that it couldn't be used for to prove the truth of the matter asserted in that statement?
Right. So there was no limiting instruction, but if it comes in as substantive, then the jurors can use that information how they want under the rule of prior consistent statement. So that's the jurors were all in the jury instructions and even in the admonishments, the preliminary instructions by the court, the jurors are always told only what's said on the stand is what, is the evidence that you're taking with you.
It was said on the stand, so, but if it was only introduced for purposes of rebutting the charge of recent fabrication, and there was an limiting instruction that it can't be used to prove the truth of the matter asserted, otherwise it would be hearsay.
The issue is that under People v. Commodore, People v. Weston, and People v. Asper, this court has never required a limiting instruction on prior consistent statement because prior consistent statements come in substantively for the truth of the matter asserted. So in that case, that's why there was no jury instruction given as far as whether to use it substantively. The word
So
is
in
not.
light of all that's what been said this morning, is it time for us to revisit those cases?
I don't think that it's time to revisit the cases because the temporal requirement is clear. If the court wants to clarify the temporal requirement, then I think, of course, the court can do that. But in the circumstances presented in this case, where she was repeatedly attacked on the stand for lying on the stand and for coming up with stories recently on the stand versus before, then I think that it was admissible. And then if not, that it was harmless error. But the cases don't have to be revisited because the temporal requirement is clear. It's just the trial courts and parties' interpretation of what the temporal requirement was below.
So are you suggesting that prior consistent statements should be automatically admissible on redirect when a witness has been extensively cross-examined?
Not that when they've been extensively cross-examined, but when it's been implied that they're lying on the stand and they've recently changed their story. So I understand that.
Isn't that the purpose of effective cross-examination, is to show that the witness is not being candid and truthful?
Correct, but as the court always highlights, the people have the burden of proof beyond a reasonable doubt. So if we let the inconsistencies go on cross-examination without correcting the record, then one, we would be failing the burden, but two, that's the purpose of redirect examination, is to rebut any inconsistencies that are had to have been alleged.
Yeah, but how the jury can weigh that, I think needs to be clarified, because while the prosecution may have the entitlement to bring in the statement under the rules, it can only be used for limited purposes. And 801, it's 801B1B, it's just to rebut a recent charge of fabrication. But here you're saying that, well, we want to correct the record. The jury can use it however it feels that it should, and it can be utilized to prove the truth of the matter asserted. And that's not the purpose of what you're introducing it for. It's just to rebut the recent fabrication on the stand, as you're arguing here this morning. So without a limiting instruction, then did the trial court err then in failing to limit that use by the jury?
The limiting instruction would not have mattered in this case, because why I keep bringing up the amount of time she was cross-examined is that her reading out those two lines took maybe 20 seconds after being cross-examined for so long on the inconsistencies that were alleged. So that's why I don't think, even if it said this is only to rebut her recent motive to lie, the jurors had all the information they needed and all the inconsistencies. And at the end of the day, they chose to believe her and find that the inconsistencies did not matter. And that's because she had called the police numerous times for this one individual. And that's why in the testimony came out from so many different police officers. That's why she was confusing the dates, but she was always consistent with the body position of the sexual assault. And so because of that, Your Honors, there is no violation of confrontation clause because they were able to present a complete defense. Even without piercing the attorney-client privilege, trial counsel did make all of these arguments that she was inconsistent and that she was even inconsistent to Guam Legal Services, inconsistent to Healing Hearts, inconsistent to the police. All of those facts came out in the trial. And given that and the fact that they were able to present a complete defense without piercing the privilege, and in light of the 2-line prior consistent statement that was allowed to come in, we would urge this court to affirm the conviction. Thank you.
All right, thank you, Mr. Mario.
Thank you.
You exceeded your time by 6 minutes, so I'll give Mr. Bischoff an additional 5 minutes if he needs it on his 3.
Thank you. So we weren't saying that the truth is she was raped from the front and that she's making up a story when she says she was raped from behind. Our case was that the mere fact that she made told these two completely different stories on the same day is proof of the fact that she's delusional. It's not a question of body position where you're raped from the front or you're raped from the behind. Either way, you're raped. If that's what we were fighting about, it would just be you were raped, but we're just talking about how you got raped. We'd be acknowledging, we'd be saying, yes, we agree you got raped, but it was from the front, not from the back. That's not what this whole prior inconsistent statement dispute is about. And as far as the confrontation, obtaining statements of evidence of statements that she made to the civil attorneys. I mean, she may have gone in and said, "Oh, wait a minute! No, I remember now. It happened differently." And oh, wait a minute, that's wrong. Oh no, it was she may have just improvised her story as she went along, telling them. Oh, I remember this now.
Argue that she waived her privilege by taking the stand to testify as to the discussions she had with Guam Legal Services?
I don't recall that I expressly made that argument at the trial. No. But I was, what we were saying that's the mere fact that she went to the Civil Law Center and talked to them and then signed a written statement that which was submitted to court that in itself.
But both the defense and prosecution asked her about the contents of her communications with Guam Legal Services, right?
Pardon me?
Both the prosecution and the defense were able to ask her about the contents of her communications with Guam Legal Services.
The contents of what was in the declaration, but nothing beyond that.
The fact that she was on the stand answering questions about that, didn't that raise ideas that potentially she might be waiving the privilege?
I think that's no different from my argument that we should have been able to get the discovery about everything that she said when she was over there. That was the whole point of subpoenaing in the attorney and the employee there to tell us all of everything that she said when she was there. That was the whole point of subpoenaing them in.
Are the tests different? Between, I think I asked you that question about the confrontation and the compulsory process in terms of evaluating that. I mean, there's the compulsory process, like, for example, the Third Circuit has a test whether the evidentiary ruling deprived you of your right to process, and that, first you couldn't present evidence in your favor. The excluded testimony, it has to be material, it has to be favorable, and that the decision was arbitrary or disproportionate to the legitimate evidentiary or procedural purpose for which it was sought. I mean, that doesn't seem to me to be a comparable test that would fit into an analysis of a confrontation clause issue. And you didn't really elaborate on that in your briefing. You just said, oh, compulsory and confrontational processes, violated, but you
Well,
never
yeah,
really-
so like I think I said before, you have to cross I think you'd have to cross the compulsory process bridge first, and then when you have that, whether you're entitled to use it to confront the witness with it.
Is there anything else, Mr. Bischoff?
Was Justice Merriman going to ask a question?
Yes, Mr. Noyer disagrees with your analysis that you never advocated for a recent fabrication. Could you comment on her saying that in your cross-examination, you implied a recent fabrication?
Well, we never said that she only recently said she was raped from the back. And when what she said before was that she was raped from the front. We weren't saying that it's a recent fabrication, because there'd be no point in saying that, in making that kind of an argument. If you're raped, you're raped. Wouldn't matter how you're raped. So in cross-examination, I pointed out several things that she had said to the policewoman, Officer Lizama, at the Dettydale precinct. But I never intimated that at the trial that her story that she was raped from the back, which she said at the Dettydale precinct, was a recent fabrication, and that the truth was that she was raped from the front. I didn't do anything like that. That's what you're asking me about. Yeah. Okay.
Right.
I think that's all.
All right, anything else? Anything else, Mr. Bischoff?
No, thank you.
All right, the court will take the matter under advisement. We will issue a written opinion, and the court now stands adjourned.
All rise.